it now falls to me to review the last 12 months and frankly trying to reflect on human rights in 20 minutes at most is a formidable challenge, as this time last year, no one could have anticipated the events to come. Nonetheless, COVID-19 is a reminder of the importance and the need for international solidarity and the value of global institutions, values and principles encapsulated in the UN and regional human rights treaties. The year commenced with the welcome restoration of the Northern Ireland Executive and Assembly and the publication of New Decade, New Approach, with its raft of ambitious commitments and a full agenda for reform. Sadly, any early testing of NDNA's mettle was quickly lost as we entered the first lockdown barely 8 weeks later. The Commission, like other organizations, has entered into a new reality, responding to the taking of emergency powers and curtailment of rights and freedoms is a challenge for human rights. Nonetheless, human rights does not take a back seat in a crisis, and the Syracuse principles on the limitations and derogation provisions in the UN's Treaty of the International Covenant of Civil and Political Rights sets out clearly that in an emergency, any restriction on rights must be prescribed in law with adequate safeguards and effective remedies and not be arbitrary or unreasonable. And any measures taken, including the severity and scope, must be no more than strictly necessary to deal with the emergency, be proportionate to the threat posed, and applied for no longer than required. And in the case of a public health emergency, due regard should be given to the international regulations of the World Health Organization. Now, some of those concepts are familiar to any examination of the European Convention on Human Rights, with its absolute and qualified rights, and with the latter's qualifications needing to be prescribed by law, to meet a legitimate aim, again be proportionate, and no more than necessary than required to meet their purpose. As ever, human rights provides a framework to operate within, rather than a neatly gift-wrapped answer to political, legal, and policy dilemmas. Nonetheless, it's the lodestar in which the Commission has operated when looking at questions of restricting statutory duties, for example, to meet needs of children in care, special educational needs provisions, questions on the right of the family members to visit loved ones in nursing homes, and many, many other practical issues that have come across what is now our virtual desks in the last 9 months. I have always seen part of the Commission's role as to ensure human rights becomes more mainstream and that everyone sees human rights as relevant to their everyday lives. And we can see that through the work of the Commission in both initiating and working with others to create the Business and Human Rights Forum, the Sport Forum, and the Economic and Social Rights work, particularly publishing a cumulative impact analysis of tax and social security policies and the effect on incomes, both those at the top 10% and those at from down to the bottom 10%. And in the development, as part of that work, of a refreshed social security mitigations package, which is economically progressive in its outcome. And in due course, we will emerge from the pandemic, and who pays for it will raise important rights issues of equity and fairness. Nonetheless, despite a mission to mainstream, the Commission cannot avoid the difficult and often divisive issues that centrally engage human rights. Sometimes we have to go where human rights takes us. 3 areas spring to mind: legacy, leaving the European Union, and abortion rights. On legacy, the Commission, alongside everyone else, from the Irish government, political parties, victims groups, human rights NGOs, and others, were taken by surprise on the 18th of March, when the government announced it was moving substantially away from the Stormont House Agreement institutions, subsequently enshrined in a draft bill, in favor of investigations which are, and I quote, effective and thorough, but quick, and only cases where there is a realistic prospect of a prosecution as a result of new compelling evidence would proceed to a full police investigation and, if necessary, prosecution. In our early meetings to divine what that meant in practice, the watchword from officials was the need for momentum towards implementation. 9 months on, we, along with others, are none the wiser about how the Article 2 Convention right to an effective investigation can be met by the counterintuitive mantra of effective, thorough, but quick. It feels to me as if the government have changed course midstream without knowing where the new destination is, while also discarding their compass and maps at the same time. And the danger of the future of any legacy process being once again clogged up in the courts looms large. And that's frankly not in the interests of anyone affected by the violence of the past, whatever his or her role or standpoint. The issue of abortion, again, has been the focus of the Commission's attention this year. The executive formation Northern Ireland Act 2019 represented the first time anywhere in the world that the recommendations of a UN treaty monitoring body's inquiry has been adopted wholesale into domestic legislation. Bryce Dixon couldn't recall any other examples, so that's good enough for me to make that claim. The Commission was given a role in the Convention on the Elimination of Discrimination Against Women's recommendations to monitor the implementation of the new arrangements that should allow women to access termination safely. The Secretary of State introduced the regulations, though it fell to the Department of Health, the Health and Social Care Board, and the Health and Social Care Trusts to fund, commission, and deliver the service respectively. To date, the department has neither approved commissioning a service nor issued any guidance on how it should be provided, including how any issues of conscientious objection from staff should be addressed. Instead, the trusts have had to provide a service by transferring staff from other sexual and reproductive health care services, either held in abeyance or reduced due to the pandemic. The issue of commissioning a service has stalled at the Northern Ireland Executive, with little sign of any zeal from the department and the Minister to push the issue towards resolution. I and my colleagues, as part of the monitoring initiative, have met all 5 trusts, the Royal Colleges of Midwives, Nursing, GPs, obstetricians and gynecologists, Informing Choices, who are the referral agency for the service, BPAS, the providers of unregulated services on the internet, the regulatory body RQIA, bodies representing pharmacists, the Catholic Church, the Department of Health, NIO officials, as well as the Health Minister, Robin Swan. Alongside that, we organised a roundtable meeting with civic society, featuring both those who were avowedly in favour of the regulations and those who were avowedly against. The overwhelming and unanimous message from both managers and clinicians delivering the service is how deeply unsatisfactory the current situation is. Health trusts, and this has been a point made to us on a number of occasions, are used to living with and managing on a daily basis risk. But they do so normally within a clear framework underpinned by guidance and a commissioning specification. Moreover, the feedback has been that the current arrangements can only be short-term and not tenable in the longer term. As a result, women's health and well-being is being placed at risk by this potential and continuing vacuum. In early October, that risk began to crystallize when the Northern Trust stopped providing a service for women seeking help. And it became apparent almost immediately that other trusts cannot pick up the slack. The options left to women in the Northern Trust is that they can either travel to Britain, largely Liverpool or Manchester, despite the public health considerations in travelling at present, or to travel elsewhere in Ireland and pay several €100 for a private service, again raising public health considerations around travel, or access unregulated services. In fact, for women in the Northern Trust area, their options are paradoxically more difficult than they were under the previous non-human rights compliant legislative arrangements. As a result of those human rights considerations at play, the Commission has again decided to commence legal action against the Secretary of State, the Northern Ireland Executive, and the Department of Health, and I would expect us to lodge the papers before Christmas. In doing so, we recognise that the courts, frankly, are no more than a lever towards finding a resolution, which has to be found politically, whether from London or Belfast. The third area I want to touch on is the equality and human rights consequences of leaving the European Union. The Commission, in its role as part of the Joint Committee, a creature of the Belfast Good Friday Agreement with the Irish Human Rights and Equality Commission, published research on the potential issues concerning the common travel area and its lack of legal underpinning, cross-border security and justice issues in the absence of retaining existing both provision and oversight and safeguards, and citizenship issues arising from the agreement. It's clear that, for example, some of the areas that fall outside the common travel area arise because Northern Ireland's land border with now another member state, issues that simply don't arise, frankly, in Britain. Cross-border childcare support and universal credit, now mercifully resolved, is one that springs to mind. We've also worked very hard in tandem with the Equality Commission to negotiate how to translate the UK government's commitment to, and again I quote, no diminution of rights, safeguards and equality of opportunity under the Belfast Good Friday Agreement into provisions within the Ireland-Northern Ireland Protocol. The non-diminution commitment is a mouthful, but it's an extremely important mouthful. We didn't achieve everything we wanted, but that's inevitable in a negotiation. But the arrangements eventually agreed in the withdrawal agreement are important and valuable. In Northern Ireland, under the agreement, we will keep pace with EU directives covering equal treatment in employment, self-employment, access to goods and services, and social security, alongside freedom from discrimination based on racial or ethnic origin. Aside from that, we now have to scope out what other parts of the relevant section of the 1998 agreement will lead to the preservation, though not future development, of rights in EU law terms. We know from the UK's government's explainer document published in August 2020, it'll cover the parental leave, pregnancy, and victims of crime rights directives. Frankly, little did the architects and negotiators of the 1998 agreement realize that over 2 decades later, we would have to dust down the agreement to see how rights can be preserved as a result of leaving the European Union. The two commissions will become dedicated mechanism from the 1st of January 2021, with a role to monitor, safeguard, and where necessary, enforce through legal action the non-diminution commitment. There will also be an all-Ireland dimension through the Joint Committee with the involvement of the Irish Human Rights and Equality Commission. I want to make one quick observation as to why these provisions are important. How important may well be determined by whether we get a free trade agreement, which will often have human rights and equality provisions contained within it. But while EU law will still play a role in all of our lives, all that's happening on the 1st of January is that EU law will no longer be supreme, and it will be up to the UK government to decide how much of the law it wishes to unpick, though this seems less problematic than the question of future development if the news reports of dinner last night are to be believed. The legal safeguards provided by the Court of the Justice of the European Union is also going over time in relation to citizens' rights and more immediately in other fields. So we're going to fall back on domestic legal safeguards. The government has embarked on an independent review of administrative law, including whether the right balance is being struck between the rights of citizens to challenge executive decisions and the need for effective and efficient government. And this week announced a second independent review into the Human Rights Act, this time to consider whether the UK government's domestic courts are being unduly drawn into areas of policy and to consider if there is room for improvement in the court's relationship with the European Court of Human Rights in Strasbourg. Now, frankly, you don't need to be a soothsayer to conclude that the government wants to recalibrate redress. And I think it's important to remember that rights are only as good as their ability to be exercised, or as the Strasbourg Court regularly puts it, rights should be real and effective, not theoretical and illusory. On legal redress, I want to mention two areas of law where the Commission has made a difference this year. We took an earlier case on retention of biometric material, DNA and fingerprints. It was settled on the basis that the Police Service of Northern Ireland would develop a human rights compliant policy in the absence of legislative compliance. That commenced before the Executive and Assembly was restored. That's been further overtaken by a different successful legal challenge in Strasbourg in the case of Gochran versus the UK. The Department of Justice is now consulting on meeting the terms of that judgment. I don't think they're there yet, but nonetheless, the proposals have been modified and they're going, I think, in the right direction. PSNI have access to around 250,000 people's fingerprints and around 200,000 people's DNA in Northern Ireland. So getting the balance right between privacy and a tool to solve crime is an important one that's worthy of wider public discussion. Second, the Commission is embarking on a challenge to the law on unspent convictions, which provide that in Northern Ireland, once convicted and sentenced to prison for more than 2.5 years, then a person's conviction can never be spent. The law operates without exception and is considerably tougher than in the rest of the UK, where a more liberal approach, or a slightly more liberal approach to be probably more accurate, is itself under further review following a white paper in August. Depending on your view of coincidence, the Department of Justice is due shortly to commence a review of its own. It's one that's unlikely to resolve our case, but it illustrates again that strategic litigation can help concentrate minds. This will be my last annual statement, and while that should be a time for reflection, there is a rather full in-tray for the next 9 months, so I don't intend to get demob happy. But the litmus test, I think, is whether the Commission is in a stronger place than it was when I took up post over 6 years ago. And has the Commission made a tangible difference? And I think that's for others to judge, not me. What I do know, however, is that as a Chief Commissioner, you can only be as good as the Commissioner colleagues and staff around you. This year, an almost complete change of the guard at Commissioner level has happened, and I want to pay tribute to the group of Commissioners who made a real contribution despite the Commission's financial strictures, which often restricted what we could do. Our new group of Commissioners are bedding in well, and they faced immediate strategic challenges and difficult decisions. And I consider the early auguries of the new Commissioners and their ability to work together as entirely positive. Frankly, I've been blessed largely with Commissioner colleagues who have been supportive, committed, and wise throughout my tenure, alongside a similarly committed and able staff team. So in conclusion, I hope you find that the annual statement is a valuable snapshot of where we are and what the Commission has done and achieved over the last 12 months. And as the proverb says, may you live in interesting times, is certainly going to apply to 2021. So thank you.